Good morning. I'm the Registrar Clerk for this hearing. Acting Deputy Chief Justice and Justices of the Constitutional Court, all counsel are online. I call the matter of Association of Mine Workers and Construction Union and others, and Anglo Gold Ashanti Limited, trading as Anglo Gold Ashanti and others for hearing. Counsel are now invited to place themselves on record. Please note that this hearing is being recorded.
May it please the court, I appear on behalf of the applicants.
Thank you, Mr. Porter.
May it please the court, I appear on behalf of the second respondent.
Thank you, Mr. Snyder.
May it please the court, I, together with Mr. Iskin, appear for the 3rd, 4th, 6th, 7th, 8th, and 10th respondents.
Thank you, Mr. Mybeck. Before we commence, Mr. Mybeck, have you sorted out the arrangement you are going to enter into with your learned friend as to who's going to commence first with his replying argument?
Yes, thank you, Justice Kampepe. With your leave, Mr. Snyder and I have agreed that I will commence on behalf of the respondents.
Okay, thank you. Mr. Porter?
As the court pleases. After 4 months of persisting with the primary strike, a failed attempt at extension of a collective agreement to AMCU members, and with retrenchment looming large, AMCU grouped together the most influential members of the Minerals Council to plan a week-long secondary strike. It did so for 2 reasons. First, there was a possibility that a spread of strikes would indirectly and negatively affect Sibania's share price and creditworthiness, and thus influence it to reach agreement. And second, the secondary employers it contended had the direct ability to possibly influence Sibania to change its mandated position because the compact that bound them permitted this. At least one of the employers, Anglo, admitted that widespread strike action is bound to scare off investors. This appears in volume 1, page 14 at paragraph 51. The court interdicted the secondary strikes, and the LAC dismissed the appeal by AMCU, finding that it was moot. It is clear from the founding affidavit in this application that the appeal to this court is against the LAC's refusal to entertain the matter based on mootness. AMCU challenges that decision expressly and clearly. To the extent that the issue of not appealing the correct decision is pressed, AMCU formally seeks an amendment to the notice of motion to align with the formulation of the relief in the concluding paragraphs of the heads of argument, just to make the issue clear. The application is 1 hour late, and it is in the interest of justice to grant condemnation. Despite the mootness, the appeal should be entertained for reasons set out in the heads, and because it is in the interest of justice. It involves a crucial section of the LRA and impacts on the right to strike. Section 66(2)(c) is at the heart of the matter. It requires that the nature and extent of the secondary strike is reasonable in relation to the possible direct or indirect effect that the secondary strike may have on the business of the primary employer. 3 aspects to the current interpretation that are in issue in this matter are as follows. The first, the current interpretation of the section imports a proportionality assessment that considers the harm suffered by the secondary employer. This AMCU contends having regard to the context and text is irrelevant. Second, the current interpretation favored by the lower courts also do not permit the grouping together of more than one employer to assess the combined impact of the strike on the business of the primary employer, the so-called cumulative construction. This AMCU contends is also contextually and textually unsound. Third, the current interpretation also permits the possibility of strike violence to be used as a means to proactively prohibit the secondary strike, which AMCU also takes issue with. AMCU contends that the current interpretation is too restrictive and undermines the right to strike and organize collectively, which exists to promote collective bargaining as the favored means for resolution of collective labor disputes. Describing secondary employers as innocent bystanders in the context of what the section requires is it is submitted an exaggeration. They are not strangers. The reasons that strikes are permitted at secondary employers is that they have the ability to possibly influence the business of the primary employer directly or indirectly to accede to the demand and thus bring an end to the strike and their own losses. This is the safeguard and only limitation. The secondary strike provides a means to draw them into the collective bargaining process to bring an end to the strike and induce a resolution. The contextual considerations that I wish to highlight are threefold. First, the present text points to a change from the industrial court approach to secondary strikes which favored the ally rather than the worker solidarity principle. This more generous approach under the LRA must be considered when having regard to the context. Second, under the constitutional framework, it is recognized that employers enjoy greater bargaining power than individual workers. Employers also have an array of legitimate collective bargaining weapons at their disposal. Indeed, members of the Minerals Council have previously grouped together to extend a wage agreement to AMCU to prevent them from striking and have the ability, in terms of their constitution, to institute collective lockouts. This is at page 862. Also, with a strike, there is a possibility of employing replacement labor, and if the economic harm gets too much, there is the possibility of retrenchment in terms of section 67.5. All of these are available independently to both primary and secondary employers. Most importantly, each one of them can collectively bargain. This power is only counterbalanced by employees having the right to strike and participate collectively in the activities of their trade union so that they may show solidarity with each other to strengthen the collective bargaining position of the primary strikers. If the worker solidarity principle is undermined, the constitutional rights are axiomatically weakened. Third, the LRA's stated purpose is inter alia to give effect to the rights mentioned in section 23 of the Constitution and to promote collective bargaining rather than court intervention in interest disputes. In construing the section, the influence of the spirit, purport, and objects of the Bill of Rights and the LRA purposes are fundamental to the context. An interpretation that is less restrictive of these rights, the right to strike and organize and bargain collectively, has to be followed. I now deal with the harm suffered by the secondary employer and why it is irrelevant. The current approach, which interprets the section as requiring an assessment of the harm to the secondary employer, undermines the contextual and textual considerations. It restricts the right to strike and participate in the activities of the unions and undermines the worker solidarity principle. It blinds itself to the remedies that employers faced with financial harm have to dismiss employees due to operational requirements. It discourages collective bargaining to resolve industrial disputes, a power that secondary employers also have, and draws the court into the power play arena. It is possible to interpret the section to give effect to the Constitution. As in Billiton and Hertex, it is submitted that to give effect to those rights, the words nature and extent of the strike should not be interpreted as referring to the effect or harm to the secondary employer or impact on its business. The nature and extent rather refer to the type of strike and extent, that is, the duration and numbers involved in workplaces. The submission that discounting the destructive effect on the secondary employer erodes the language is wrong. It is the other way around. Including it involves the reading into the proportionality requirement of the section. The text requires to be strained to read in this requirement. The wording does not clearly import this requirement, which restricts the right to strike and organize. This requirement of the harm to the secondary employer could have been easily expressed if that were the intended meaning, as easily as it was to emphasize the effect on the business of the primary employer, which finds expression in the second part. The words reasonable in relation to contained in section 66(2)(c) does not import a proportionality assessment into the harm to the secondary employer, but rather imports an assessment into the impact on the business of the primary employer. The words in relation to identify the specific and only relevant comparator. The only inquiry relates to whether the pressure may possibly directly or indirectly affect the primary employer's business. Reading in the secondary employer harm requirement is incongruent and creates an absurdity and tension, as the whole point of a strike is to cause economic harm. The greater the harm, the greater the possibility of influence. The collective strength of workers at majority employers cannot be used otherwise, because the harm will always be greater where the strength is greater. It gets the court involved in the arena of power play, which is not sanctioned by the LRA, which leaves it to the parties to resolve their disputes through collective bargaining. Only weak secondary strikes.
Mr. Porter, your 10 minutes.
I've lost, I think, Justice Kampepe, you are on mute. I'm sorry.
Can you hear me now?
Yes, yes.
Yes, I'm saying your 10 minutes, your 10 minutes protection time has expired. You may expect questions from the bench.
As a court, please. I'll continue until I get questions.
Mr. Border, can you just clarify me just on the point that you are dealing with? When a secondary employer wishes to apply for an interdict in the labor court, the secondary employer would then do so in terms of section 66(3). Is that correct?
Yes, yes, Justice.
What would be the aim? What would be the purpose? Or what would be the secondary employer seeking in invoking section 66(3)?
To stop the strike.
And what would be the end result? What would be the objective? What would be the what would be the remedy that the secondary employer would be seeking?
It would seek an interdict, and I submit it would be entitled to the interdict if the threshold requirement is not met. And that threshold requirement is that there is no possible ability that it has to influence the primary employer to change its bargaining position.
Well, the purpose of my call is really to check whether the secondary employer would be required to show to the labor court that it is suffering any sort of harm as a result of the strike.
That would flow from the requirements of an interdict, which one of the requirements is irreparable harm. But the point at this point here is whether in establishing the first part of the requirement, that is whether there's a clear right to strike, whether this fact is a factor in that assessment. So what the courts have done is to look at the section and say that at the level of determining the clear right, or if it's an interim interdict, the prima facie right, at that level, the question of harm must be factored in order to determine whether there's a right to strike or not. And that is what we take issue with. Obviously, in the context of an interdict, irreparable harm is a normal requirement, but that is a self-standing requirement based on interdicts.
So would the labor court then have to look at the nature and the extent of the harm on the secondary employer when deciding whether to grant the interdict or not?
Only at the level of the second requirement, not at the level of determining whether there's a clear right to strike, which is where the inquiry or the application succeeded here, because what the court did here was, the labor court was...
I just want to establish the principle first. I just want to establish the principle first. And if we can just leave the facts of this matter aside for a minute and just look at the legal principle, because my understanding is that you have approached this court in order for this court to set the legal principle, the correct test to be applicable in these kind of matters.
That's correct, Justice. So just the focus of the debate, the correct test is in relation to the interpretation of the section. And the question is whether at that point, and this goes to whether there's a clear right to the interdict or whether there's a clear right to strike in a given case, whether the question of harm is factored in at that point. And we submit that it should not factor in at that point. The only relevant consideration is whether or not the secondary employers have the possibility of directly or indirectly influencing the primary employer. So at the level of determining whether the strike is protected or unprotected, the question of harm does not come in. And if the employers fail in establishing a clear or prima facie right, the second requirement of an interdict doesn't come into consideration at all. So if they fail to establish that the strike is unprotected because the threshold requirements of the section are not met, that's the end of the matter. The question of harm would not enter the debate in that context, because the first requirement of an interdict would fail.
If the secondary employer is able or concedes that in fact the strike is protected, they cannot approach the court. Is that what you're saying? They cannot approach
Yes.
the labor court and
Yes.
say that I'm suffering harm.
Yes.
And the primary employer seems not to be bothered by this, and we're not able to put pressure on the primary employer.
Yes, it will not then meet the first requirement of an interdict, which to establish a clear or prima facie right. But the remedies that it would have in that instance would be first to try and engage in collective bargaining with the primary employer. And secondly, if the financial harm is of such a nature that it is affecting its business, the LRA expressly in section 67.3 gives secondary employers the right in the context of strike to invoke dismissals for operational requirements. So the remedy is not to stop the strike. The secondary employer has its own remedies in determining, in having to deal with the question of its financial harm. Obviously, in the context there, where it seeks to invoke retrenchment, it then draws the union into the consultation process to try and persuade it not to go ahead with the strike because of its ailing business. And that is the subject matter that could be drawn into the 189 retrenchment consultation. So that is the proper remedy that they have, I submit.
Well, just one last point on this. Whilst reflecting on this, I wondered, and also having read the CLIDET, where the secondary employer would get the evidence or obtain the evidence of the harm that the primary employer has suffered. That is the nature and extent of the harm that the primary employer has suffered. Let's say the primary employer is not joined and the primary employer is not having a relationship or has not been cited as it happened in CLIDET and in Coca-Cola. In order to prove that there is, let me read the section, the section properly. In order to prove the nature and extent of the secondary strike and in relation to the possible direct or indirect effect that the strike has on the business of the primary employer, where would the secondary employer get that evidence?
Well, if the secondary employer has no ability whatsoever to either directly or indirectly influence the primary employer, then the secondary employer would then have established that the strike is unprotected. So it's a question of fact in a given case whether the secondary employer, a strike at the secondary employer would have the effect of either directly or indirectly affecting the business of the primary employer. So there is a question that will have to be determined on a case-by-case basis. In this case, the AMCU's case was that the influence was indirect in the sense that the share price and the attraction to invest in Sibania will be affected through a spread of strikes, and so the Act doesn't require a direct commercial relationship between the parties. It simply requires a direct or indirect effect. But secondly, there was a relationship, as AMCU said, through the compact, and I've dealt with that in the heads of argument. So in this case, where there is no ability of the second employer to directly or of the secondary strike to directly or indirectly affect the primary employer's business, then the interdict should properly be granted. but financial harm of the secondary employer is not relevant to that inquiry. I hope I've answered the question.
Mr. Bora,
Thanks, Mr. Bora.
Mr. Bora, I have some reservations in how the interdict issue in section 66.3 is approached. Can I get clarity on this? Is the secondary employer obliged to establish the elements of an interdict before succeeding in a claim based on section 66 sub 3?
Yes.
Why?
Let me just...
You see, let me tell you where I'm coming from, Mr. Boda. When you look at section 66 sub 3, you see that it confers a claim or a right on the secondary employer to go to court and seek an interdict. And it tells you the condition. The interdict may be sought only if the secondary strike contravenes section 66 sub 2. Now, I'm in difficulty in understanding the purpose of proving, for example, that you have a clear right when the statute itself grants you the right. So can there be a situation where the secondary employer goes to court and proves that the secondary strike is in contravention of section 2? Can the court refuse to grant an interdict by saying, well, you haven't shown some or one of the elements of an interdict under the common law? Can it do that?
No, so maybe if I can make my submission clear, in dealing with the requirements of an interdict, the first thing is to establish a clear or prima facie right. So that would be what would be required is to prove a breach of section 68(2)(3). That's the starting point.
Now, isn't it to prove that I am a secondary employer who is facing a secondary strike? Isn't that, because that's the person on whom the claim is conferred by the section. Otherwise, if I'm not a secondary employer, I cannot go to court and seek an interdict under subsection 3. Even if I am a primary employer, I can't do that because subsection 3 confers the right on the secondary employer, isn't it?
Yes, but it would still be subject to proving that the strike offends either section 68.
I agree with you, but that is the condition of getting that claim, of proving the claim. You can only get your interdict if you can show that the strike does not comply with subsection 2. That's what it says.
Yes.
So I think really it may cause confusion to say, well, even if you have proved that you're a secondary employer, you have proved that the strike contravenes subsection 2, you still have to prove the elements of an interdict as we know them. I'm not quite sure that that's the correct approach.
I mean, I don't see any tension, because the requirements of saying subject to 668(2) and 3, I'm simply have conflated that with having to establish the first part of the interdict, which is a clear right. So if one doesn't show a contravention of 68(2) or 3, one doesn't show a clear right. But I understand from the text what you're saying,
okay.
Justice.
Okay.
I understand what you're saying.
All right, thank you. Can I ask something different? I understood you during the early part of your argument to be saying that the matter is moot. Is it moot?
Well, in the sense that the strike itself, that particular strike was settled, but for future matters,
okay.
AMCU still may want to.
So you're not asking for any relief to be executed against the employers. You are asking for the determination of the correct interpretation of the relevant section for future applications.
Yes, and it would have an impact if the court finds that a labor court had applied the wrong interpretation, and obviously the consequence of the decision would be to the interdict should have been dismissed, and then there's a cost order. There are 2 cost orders against AMCU, which one in the leave to appeal and one in the labor appeal court, which obviously would have to be set
affected
aside
by the outcome.
Yes.
Okay, I understand. I just wanted to find out the scope of this matter. What are we to deal with? As I understand now, what we need to focus on is the correct interpretation of section 66 sub 2.
Yes.
And then that interpretation might have a bearing on the cost orders which were issued by the courts below.
Yes. Correct.
So that's in a nutshell what we're dealing with. We don't need to look at the facts, because when we're doing interpretation, the facts are irrelevant.
No, I mean, I don't think the facts are of particular importance, other than as an indication of how to apply what the law is. Yes, I agree with you, Justice Shefter.
Okay, all right. Okay, no, let me stop there. I think I've clarified, because I wasn't sure how far we should go with the whole exercise, whether it's just an exercise of interpretation and then leading to something else. Thank you.
Mr. Boda, I want to follow up on the questions raised with you by my sister Justice Chik. On the question of reasonableness. I want to have a clearer idea on the inner and outer contours of the concept of reasonableness in the context of paragraph C of section 66(2). I have in mind this scenario, and I think one of the respondents does touch on it. Say a scenario where there is a huge impact, say even a ruinous or potentially ruinous impact on the business of a secondary employer. The impact of the secondary strike, that is, weighed against a very minimal direct or indirect benefit with regard to what the employees are seeking. Just explain to me why it is that the reasonableness concept has no bearing at all to this potentially ruinous impact on the business of the secondary, and just why would that be?
Yes, so if I could respond in the following way. First, contextually, and that's in the scope of the entire LRA. Every single strike, whether it's a primary strike or a secondary strike, once it's protected, could have a ruinous impact on an employer. That is not a ground when I take primary strikes for an interdict, because contextually, the LRA permits an employer in those instances to invoke its right to retrench for operational requirements. So that's the first, the contextual portion of my submission. From the text itself, if one looks at the text itself, the words reasonable in relation to contained in section 66 to C, it's specifically directed at, and the text says, the nature and extent of the secondary strike is reasonable. Then it goes on to say, in relation to the possible direct or indirect effect that the secondary strike may have on the business of the primary employer. So from a textual point of view, the question of harm does not come in. And the reason that the question of harm does not come in is because if that was a factor, it could have been as easily stated as it is stated for the secondary employer, where the legislature has said the secondary strike may have on the business of the primary employer. It states that very, very clearly. That type of categoric statement when it comes to the secondary employer is not there. So that the only inquiry in terms of section 66 to C is simply whether the nature and extent of the secondary strike is reasonable in relation to the possible direct or indirect effect the secondary strike may have on the business of the primary employer. So from a textual point of view, my submission is that the words nature and extent do not refer to the financial harm that a secondary employer may face. And because that is an ordinary consequence of every strike. And that the remedy of the secondary employer who is faced with financial harm where the strike is protected, and this was a compromise reached at NEDLAC by the social bargaining partners, is one of two things. They can get involved in the collective bargaining process, which is the preferred way in which power play matters are resolved. And secondly, they can use their power to retrench if the strike has reached a scale where the business is possibly going to be ruined. And in that context, the union is drawn into a consultation process where that becomes a factor at the forefront. But it's not a basis. It's not a basis to prohibit the strike. And that is what that is my submission.
I have two difficulties with that response, Mr. Border. The first relates to your very emphatic preface, which is about the importance of context. What I've very strange in your response is that having emphasized context, you forget at all what the context is insofar as the secondary employer is concerned. That context is that the secondary employer, unlike the primary employer, is not in a position where it can easily bring about an end to the strike. It may be true to an extent with the primary employer, but the primary employer is better placed to bring an end to the primary strike. Yes, I know you will say, but the secondary employer can bring pressure to bear and so on and so on. But the fact is the secondary employer is in a totally different position compared to the primary employer. That's part of the context, which you say nothing about whatsoever.
No.
No, please wait.
Sorry.
I know you did touch on part of what I'm raising with you when you were responding to Justice Chikri. But I say I do not see how, in terms of context, you may simply want to equate the primary employer with the, or rather the secondary employer with the primary employer. That's the first difficulty I have. Then the second difficulty, and of course I'll request you to please deal with both. The second difficulty relates to how you seem to curtail or restrict the meaning of nature and extent. Why is it that nature and extent cannot relate to even the impact that the strike is going to have on the business of the secondary strike? Just why should that be so? Is it purely, as you seem to be arguing, is it purely the fact that this is a strike and therefore the impact is irrelevant? Irrelevant in the context that I've just explained. I have difficulties with that.
Okay, I'll do my best to answer both. So as for the first part of it, the protection afforded to secondary employers, and this is part of giving effect to the constitutional right to strike, is that if there is no possibility of a direct or indirect effect on the business of the primary employer, then the threshold requirement of the section is not met. And the wording is deliberately broad in terms of only requiring a possible direct or indirect effect. And the reason that the wording is broad is to give effect to the constitutional right to strike, which makes no distinction between primary and secondary strikes. So in circumstances where a court is not satisfied that the secondary employer has a strike at the secondary employer would possibly directly or indirectly affect the primary employer's business, the interdict in that event should be granted. So that's my response to the first portion of the question. Sorry, if Justice Madlanga, if you can just repeat the second one, I just lost my train of thought. You said a second
Yes,
part of it.
that one relates to what I see as you possibly restricting the or the reach in the sense of REACH of open quote, extend close quote, and open quote, nature close quote.
Yes. So with this, there are two possible interpretations. There's no question. And that's why you have divergent authorities. So it is possible, and I'll have to concede it is possible to read extend to include what the courts have already said. But the question is whether that is proper, and is that does that correctly give effect to the right to strike, or is that reading in too much of a limitation that would undermine the right to strike? And so these issues were considered by Pillay J in the two decisions, where in looking at why this requirement should not be a factor, she emphasized two things. The one is that it inevitably draws in the court to a power play dynamic in assessing whether financial harm is of such a nature to undermine a constitutional right. And that is generally not something that the LRA encourages, because what it encourages is for the parties to resolve their disputes through collective bargaining. So by reading into this requirement, the court is being drawn into the power play dynamics, whereas the LRA allows certain mechanisms to give the employer or provides mechanisms to the employer, remedies to the employer to alleviate its financial harm. And those are twofold, as I've said. One is to engage in collective bargaining. It can do so at two levels with the primary employer. If it can't engage in collective bargaining with the primary employer, the strike is unprotected, because then it has no a direct or indirect ability to influence it. But if it can, then that is one of its remedy. And the second remedy is the ordinary remedy, which is to utilize its power to dismiss. It also has other remedies to alleviate financial harm. It can employ replacement labor. It can institute a lockout. There's all of those remedies that the LRA has. So the text, yes, there's no question. You have two divergent opinions, and the text is then capable of two possible interpretations. But my submission is that the interpretation that promotes the right to strike, which does not distinguish between secondary and primary strikes, is the one that should be favored, and the considerations are there in those decisions, and that's what I would rely on. I hope I've answered.
Thank you, Mr. Boda. I'm happy that you have now reached a point where you actually accept that there is room for both interpretations, but of course, and understandably, you prefer the interpretation advanced by your client. That calls to mind Section 22 of the Constitution, the right to conduct one's trade or profession or something like that, which in this instance, to my mind, bears relevance to the business of the secondary employer. Here I am a secondary employer. I'm minding my business. I'm taking very good care of my employees. We are all happy. They have no complaints whatsoever with regard to conditions and no complaints at all with regard to pay. But then something happens elsewhere, which I really don't have much control over. Isn't the Section 22 right of some relevance, and should it not bear relevance on the interpretative exercise? And I take your point with regard to the right to strike. But then, because there's the right to strike and also the Section 22 right, isn't that exactly what would require that there be this proportionality exercise? And if that be so, wouldn't that be reason enough for the interpretation that you do not favor to be the interpretation that carries the day?
So, I mean, obviously all constitutional rights are relevant to the inquiry. I would not be able to contend otherwise. But there's actually two rights at play for the workers here. It's the right to strike and the right to participate in the activities and programs of an employer's organization. And that's where I get back to the principle of worker solidarity, because one can't utilize the right of an employer to trade and factor it in such a way where what the LRA is doing and the primary right that it is promoting here are the constitutional rights of workers. So this has the potential of denying workers solidarity, where workers at other employers want to stand in solidarity with their colleagues in the primary employer. So one must also look at that principle when determining whether this is a relevant factor. And if one looks at what the whole purpose of the secondary strike is, it's primarily to promote worker solidarity. So that principle can't undermine situations where workers who have common interest, and in this case, I'm just using it as an example, they have common interest in the mining in the mining industry to uplift social conditions of workers generally. So it cannot be at the expense of worker solidarity, especially given the fact that that the premise must be that workers on their own don't have power to negotiate. Their strength lies in the solidarity that they can master. And if the solidarity is not enough at the primary employer, they should be entitled to draw from the ranks of secondary employers to strengthen their solidarity. The reason being is the secondary employer is now drawn into the collective bargaining process. And that is the preferred method for resolution of these power play dynamics. Because if there's no threshold, if the secondary employer cannot in any way influence the primary employer, then the threshold of the section is not met. But where it can, it is now able to use its collective bargaining strength, and the court will have to be satisfied it has some strength, otherwise there's no point in granting a strike, to alleviate its own difficulties. And that could mean placing pressure on the primary employer, but also placing pressure on the union by telling the union, you've drawn me into this. You should really seriously consider your position. It may turn out that you're going to impact the jobs of the people who are now standing in solidarity with you. So it may be you want to temper your demands to take into account those considerations. So what overrides in this, what overrides in determining this, is the promotion of collective bargaining, the promotion of the right to strike, the promotion of worker solidarity. And if reading in harm into the section, just look at the law reports. Secondary strikes generally fail. I mean, interdicts are granted. I mean, we got the Salga one where it was a one-day strike against government. One can understand why the court would allow it. But I can't imagine any private secondary employer ever not being able to show loss, not being able to go to court to say, this is going to bring ruin to me. We're suffering millions of rands of loss. It's going to undermine the right of workers to stand in solidarity with each other. And that is the point that I wish to drive home, hopefully, Justice Matana.
Thank you very much, Mr. Boda. Thank you.
Can I take that up further, sorry, Mr. Boda. Sorry, can I take that up further? It seems to me that the right to strike in Section 23 is general, but then the LRA makes a pertinent distinction between primary and secondary strikes by legislating sections 64 and 65 on the one hand, and then pertinently 66 on the other hand. It seems to me that there must be a reason for that distinction, and the reason is then to be found in 66, which places specific provisions in respect of secondary strikes, which this court must heed. It seems to me that, therefore, to say that the impact, either direct or indirect, on the secondary employer is irrelevant, is to render that section nugatory. Because the way you read the section, and I'm turning to section 66(2)(c) in particular, you start reading by saying reasonableness must be in relation to the possible direct or indirect effect that the secondary strike may have on the business of the primary employer. And you say the words, the text itself is clear. But surely you got to read, as you read any section, you must read the entire section. You must start at the beginning, which is always a good place to start. The nature and extent of the secondary strike is reasonable in relation to. Here we got to compare two things, because in relation to means a weighing up of two things. The first thing, as I read the section, is the nature and extent of the secondary strike. That's the first part. And that must be the nature and extent as it bears on the secondary employer, must then be weighed in relation to the possible impact that it may have on the business of the primary employer. So you can't completely and utterly negate the first part of the provision by ignoring the impact on the secondary strike. Is that not a proper way of reading it?
So as I've said, there are two divergent ways to read the section.
Well, I'm trying to explore why the view of Salga 1 and Salga 2 is the preferable one.
So when one looks at the second part of the section, I just want to emphasize this. the words are clear when it comes to the primary employer. It says very clearly, the secondary strike, the direct or indirect effect the secondary strike may have on the business of the primary employer. It's very clearly stated there. Now, if the impact of the strike on the secondary employer is relevant, it could have been stated as clearly, but one doesn't have a disjointed section which says the nature and extent of the secondary strike is reasonable in relation to the harm that it could bring on the primary employer. The nature and extent is not the nature and extent of the harm to the secondary employer. The nature and extent is the nature and extent of the secondary strike. So there's a change in the wording from the first part to the second part. The second part emphasizes the business of the primary employer. The first part emphasizes when it deals with the nature and extent of the secondary strike. It doesn't say the nature and extent of the impact on the secondary employer. It says the nature and extent of the secondary strike. So the focus then is on the strike itself, and that's why I submit the decisions that we have advanced in this case are correct, because that focuses on the type of strike, the workplaces affected, and those requirements. It doesn't focus on the harm to the secondary employer, because that is not mentioned. And if one were to read that in a broad sense, it would have to be clear, because ultimately, while it is so that the LRA distinguishes between primary and secondary strikes, the Constitution doesn't make any distinction between primary and secondary strikes. It just guarantees the right to strike. And also, the Constitution specifically guarantees the right of workers to join in the activities of their trade union, which is the worker solidarity principle. So I don't want to repeat what I've said earlier.
Yes, sir. Yes, I've heard that argument. Mr. Boda, I'm not against you on the second part. It's clear the second part clearly is what must be weighed on the other end. I'm starting with the first part, and you say nature and effect of the secondary strike means only what kind of strike is it, and secondly, how long is the strike? I find that difficult to accept. But let me move on and say this. Leaving quite aside the evidence of Mr. Froneman, because we've agreed that we won't look at the evidence, but the evidence seems to me to be clear that Sibanye's share price was unaffected by a almost 5 month long strike. On the contrary, the share price kept on rising. It was one of the star performers on the JSE. That's something that one could ascertain objectively by just looking at the JSE share price indexes and history. But quite apart from that, it seems to me that here we have a secondary employer, quite unrelated to the fight in inverted commas between the employer and the employee in the primary strike, Sibanye and AMCU. It's got no control over the collective bargaining process there, about negotiations and so on. It is simply an innocent bystander, and now it gets drawn into this skirmish. And on your interpretation of the section, it cannot do anything to affect that outcome, because really, as one of the respondents put it, it's in a boxing match between two pugilists, and it's been drawn in, and his hands are tied behind his back on your interpretation. I can't see how that can possibly be what the legislature had in mind, bearing in mind what my brother Madlanga has emphasized, the right in section 22 that surely these employers must have.
When it gets into the facts, it's not only on the share price, it's on and the standard is only possibility, not more. It doesn't have to be probable that it affects the ultimate business of the primary employer. It's a very low threshold. It's a possibility. There was evidence that on the day that the strike was announced, the secondary strike was announced, the share price fell. But it's more than that. It's about investor confidence in the general mining industry, and that, in fact, as I've mentioned, Anglo at volume 1, page 14, paragraph 51, actually says that widespread strikes is bound to scare off investors. And so there is then an indirect impact on Sibania's business. If investors are going to be scared off, it stands to reason that there's a possibility that they won't invest in shares or will divest their shares, and it may possibly affect the share price. Secondly, the parties are not strangers. If they were, obviously, then the threshold requirement are not met. We've set out what binds them in the Minerals Council Compact, and have dealt with this comprehensively in the heads. And one of the express provisions in the Mineral Council Compact is that one member has the right to try and persuade the other member to change their mandated positions. And so there is and this is at paragraph 119 of my heads, where the compact says it expressly provides that mandated positions can only be changed after any contrary views have been debated by the Council of the Minerals Council and agreed upon. So where the business of the secondary employer is being affected by this, they are entitled to invoke the compact, try and persuade Sibania to change its mandated positions to have to take into account their interests. And those are my submissions. I think I've set it out.
I'm sorry, Mr. Border. I was trying to avoid this when I said we should stick to the law and interpretation, because we can't interpret section 66 sub 2 through the lens of the existence of Mineral Council and compactors, because the section applies widely. It applies even in situations where there's no Mineral Council. So can we not spend time on the facts? Let's spend time.
I agree, Jeff. I was just responding. I agree with there's no principal reason to get involved in the facts of the matter.
Yes, but just as a follow-up to the debate that you had with Justice Madlanga and also Justice Majid, isn't it that the literal interpretation that your client is advancing seems to be in favor of the workers as against the secondary employer? Because the context would have been that what would have led to a strike would not have been triggered by the secondary employer. It would have been, as it has been described, a fight happening elsewhere. So isn't it that that interpretation favors the striking workers at the expense of the secondary employer?
It does, I would agree, but it does that in the context of recognizing what remedies the secondary employer has, and what would happen if secondary strikes are limited at the expense of worker solidarity. So one has to look at the other powers that secondary employers have, like primary employers, which are found in the LRA, which I've already articulated. The right to engage in collective bargaining, because you're now drawn into that, and that is the preferred method for resolving industrial disputes. So that is one remedy it has, and the other remedies I've already invoked. So,
but can you engage in collective bargaining there? Because I would assume that before we get to the primary strike, there would have been collective bargaining between the two parties. And if there's no agreement, then a dispute is declared. And the workers might go the route of a strike after giving notice. Now, if you are a secondary employer, would you have been entitled to sit at the bargaining meeting before the strike, the primary strike was embarked upon?
No, certainly not. Certainly
So
not.
what collective bargaining are you talking about?
So the whole reason why strikes, as I understand it, are allowed is to force parties back to the table to reach agreement.
I agree.
So when the strike's happening, the negotiations don't end. So the whole point of a strike is for them to come together. So now you're bringing in the secondary employer and the workers at the secondary employer. They can now enter this because that's the threshold requirement of the section. They must have, it must be able to directly or indirectly impact on the business of the primary employer. And that suggests that what the legislature is promoting is for the secondary employer to enter into the collective bargaining between the parties. And it could be with the union and it could be also with the employer. It is now drawn into this power play and it becomes a collective bargaining partner now to try and exert influence over the primary employer. So the collective bargaining doesn't end because a deadlock was reached. It carries on and it gains strength by the solidarity from other workers.
So you're saying a strike, a secondary strike entitles the secondary employer to get into the bargaining meeting in respect of the issues between the primary employer and its workers. Is that the submission?
My submission is that the secondary employer has, because that's a threshold, the strike there has to directly or indirectly affect the business of the primary employer. So where this is happening and there is a scenario where the secondary employer can persuade the primary employer to relent, or even the workers, because other workers are drawn in and it may persuade the union to relent. Nothing stops it from now being drawn into the collective bargaining in order to try and bring resolution to the dispute.
And am I wrong to assume on your argument the word effect, direct or indirect effect, on the business of the primary employer should be construed to mean leverage by the secondary employer upon the primary employer, where
Yes.
the secondary employer can put pressure on the primary employer? Is
Yes.
that how we should read it?
Yes.
Okay.
Mr. Bora, can I just conclude my questions? I want to ask you one final question. I want to understand your argument. Are you saying there is no proportionality assessment here in section 66(2)(c? Or are you saying, yes, there is a proportionality assessment that must be done, but that proportionality assessment does not involve the harm, possible harm on the secondary employers? What is your
The second proposition?
Yeah. So what does it involve as far as the secondary employer is concerned? What must be assessed?
Only the direct or indirect effect that the secondary strike may have on the business of the primary employer. The nature and extent, as indicated in the authorities that we have, the Hertex decision is referring to the nature and extent of the strike itself, not the harm on the business. So it's the second one. Yes, there is an assessment to be made between two things. What goes into that is what the debate's about.
Thank you.
It's the second.
Yeah.
Mr. Boda, just to follow up on that, then your submission, well, that is how you would interpret the interpretation you'd advance for the words in relation to in section 66(2) sub C.
Yes. It doesn't affect it's not in relation to the harm to the secondary employer. It's in relation only to one fact, the effect on the business of the primary employer. So if there was going to be a comparison of the secondary employer's business, it could have been stated as clearly as that. That's what I'm saying.
Yes, thank you.
If I may follow up on that.
Follow up on that.
Yeah. Okay.
Why didn't the section then simply say that carrying on from subsection B and say, and the possible direct or indirect effect that the secondary strike may have on the business of the primary employer, and exclude the first portion about the nature and extent of the secondary strike. If we're to read it that way, it seems to me then you are urging us to excise the first portion.
No, I'm saying that the first portion should be given a meaning which promotes the right to strike, and it refers to what was said in Bulletin and her text. The nature and extent refers to the type of strike, whether it's a go slow or partial or full strike, and the extent refers to the duration, the numbers involved in the workplaces, but does not extend to the direct or indirect effect that the strike may have on the business of the secondary employer. So I'm not suggesting that the first part at all should be excised. I'm saying it should be given a restricted meaning as it was given in the decisions of Bulletin and her text to promote the right to strike.
I hear you.
Mr. Boda, if there are no other colleagues wanting to raise, I think my brother Claletti wished to say something before I come in.
Yeah, no, actually, I am covered mostly by my colleagues there. But what I wanted to ask again is what would be the rationale to protect the business interest of the primary employer only in your interpretation of this section?
I don't think the rationale is to protect the business interests of the primary employer, because the business interest is already jeopardized by a protected strike. The strike is already happening. The rationale is to influence the the primary employer to reach agreement with the union. So the rationale for the section is to induce the parties by a broadening of the strike to reach a collective consensus. So what the section is aimed at doing is to permit secondary strikes to have an impact on the business of the primary employer with a view ultimately to encouraging a collectively bargained outcome. Then it's not about the financial harm to the primary employer, because that is a given. It's already suffered harm.
Yes, then should one not consider whether is it possible then for the secondary employer to reach that goal of influencing?
Yes.
Whether is it possible?
That part I have no difficulty with of the test. That part is expressed. The secondary employer, for the strike to be protected, the secondary employer or the strike at the secondary employer, it must be shown that it will have a direct or indirect effect on the business of the primary employer.
Thank you.
I don't have a difficulty with that part of the test at all.
Thank you.
Mr. Boda, can you hear me?
Yes, Justice Pillay.
So the critical and primary inquiry is to establish whether there's an effect of the secondary strike on the primary employer and the primary strike.
Yes.
That's a starting point. So I accept that the threshold is very low. The use of the words possible and the use of the word indirect tend toward, lower the threshold and bring in the notion of solidarity or ally strike.
Yes. So,
but to establish the effect, that is a fact-sensitive inquiry.
Yes.
And that's the basis on which the LAC in Billiton, Judge President Zondo wrote that judgment, and both Salga judgments were decided on the facts, although in the Salga judgments, there was a view expressed about proportionality.
Yes, I would agree with that, Justice.
Okay, then on the proportionality question, the words nature and extent suggest that there's a proportionality inquiry. And what I hear you accept is that there is a proportionality inquiry, but that comes in once there is evidence that there is an effect. Because if there's no effect, you don't go into a proportionality inquiry. The strike doesn't meet the threshold requirements.
Yes, correct.
So if you didn't have nature and extent there, and if there wasn't a proportionality inquiry that looked to the impact of the strike on the secondary employer, then the possibility exists that the section could operate as an ouster of the Constitution.
Yes.
And constitutional rights. That's why you must accept that, as you do, that the nature and extent includes a proportionality analysis of the impact of the secondary strike on the secondary employer.
On the primary employer.
And the secondary employer. Because that's what I understand your concession to be. I'm not going yet into the question of the power play.
Yeah. I'm not conceding that the nature and extent refers to any proportionality assessment on the business of the secondary employer. The nature and extent only refers to the assessment relates to the nature and extent of the strike in relation to the business of the primary employer.
Yes, the text suggests that, but I understood your concession to my brother Jafta that you cannot exclude the operation of the Constitution, and proportionality enters the equation through the Constitution.
Yes.
But by saying that, by interpreting nature and extent as not operating as an ouster clause to the Constitution, but and because then there would be a whole legality challenge and so on. But so my question then is, if you're saying that there is a proportionality analysis, that it does not arise in relation to the secondary employer and the harm it suffers in relation to the secondary strike out of section 66 to C.
Yes.
But you must concede that it could arise out of the Constitution. My brother Madlanga pointed out section 22, which is where I want to go next. That's one.
Yes, but then that, sorry.
That's just one of the possible sections.
Yes.
We'll talk about that now. But the possibility also exists that the harm on the secondary employer could impact on third parties, could have other harms. So, for instance, a SELGA strike, which results in the shutdown of hospitals or essential services. That's a harm where the constitutional right to strike must be balanced against the constitutional rights of other people, health, security, and that would include if there's a risk to safety and security, because the strike involves an element of violence. The employer, secondary employer, if it makes out a case that the effect, nature and effect, because nature and effect, so nature and extent of the strike, nature could involve a violent strike, a strike involving violence. If there is that element and the employer says these strikes and encourage violence, would encourage, has a history of violence, and makes out that case, then safety and security balanced against the right to strike under the Constitution, I'm not talking about 66, would come into play.
Under the Constitution, but that would be a completely different case about whether the the text is sufficient enough to meet all constitutional requirements and whether employees' interests are properly protected. But that would not be a case about interpretation. Then it would be a case about justifiability.
It's a different proportionality test, but the interpretation of nature and extent takes you there.
I don't see it as a mirror of the constitutional proportionality test in the limitations clause. It's more restricted than that. And to the extent that that employer says it's not big, broad enough or whatever, then that is a debate that would have to happen on another day about whether the text meets the requirements of justifiability. But that is not a question in this matter.
Yes, no, I agree that the case of balancing constitutional rights qua constitution is not before us.
Yes.
We're busy with nature and extent.
Yes.
And I'm going back to the concession you made, and with which I agree, that nature and extent is wide enough to bring into the equation the impact of the strike on the employer. But one accepts in that equation the relevance and importance of power play.
Yes.
So one doesn't interfere with power play for the sake of interfering with it or rebalancing that. There has to be some other consideration, such as other constitutional rights being implicated.
Yes. Safe to state that the nature and extent is what we've advanced from Bulletin and her text, that is our case. It doesn't go broader than that. I have not, just to make that clear, I'm not making any concession beyond Bulletin and her text in relation to this.
Well, both cases are my judgments, and particularly Hextex raises the constitutional angle more pertinently. Yes. And the possibility that you've got to look at section 66 to C in that context. Now, so when we go, let me just go back to the notion of, not the notion, but the wording of possible direct or indirect effect. Possible can't be purely notional. That would be too low a threshold.
Yes.
And solidarity cannot be the only basis. So if there's solidarity but no other basis for a secondary strike, can there be a strike? So, because if that is the case, then you can have a strike in the dairy industry,
yes,
where another CASATU or other federation, sister organization, union can strike, and that is entirely solidarity.
Yes. Well, I'm not advancing a case of pure solidarity. It's solidarity with a limitation.
And then the last question, I'm not sure to what extent the applicant is serious when it suggests that replacement labor retrenchments are options to mitigate the harm. Because I understood when I last looked that replacement labor was repugnant to trade unionism, and it is very highly regulated in the Labor Relations Act. And also they would fight retrenchments, not something that is in the interests of trade unions. So is that a cynical suggestion, or should one
take... what I'm saying is that one understands that strikes bring about financial harm, including financial harm to secondary employers. However, there are remedies that the LRA gives to alleviate those harms in certain circumstances. One of them is to obviously respond by a way of a defensive lockout and then employ replacement labor, which is a method of alleviating financial harm. And the second, which is in the strike section itself, which is section 67.4, under the chapter strike or lockout, it's that an employer section 67(4) and 5. Section 67(5) says subsection 4 does not preclude an employer from fairly dismissing an employee in accordance with the provisions of Chapter 8 for a reason related to the employee's conduct during a strike or a reason based on the employee's operational requirements. So what I'm saying is that when looking at the chapter as a whole, one has to look at this compromise that the LRA has reached that allows employers faced with a grave financial difficulty the right to invoke their operational requirements to retrench workers. And so it's in that context that I'm saying one has to these rights that secondary employers or primary employers have to inform the interpretation of the section. One has to look at it in the context of those remedies. And that is why financial harm is not relevant to the inquiry as to whether the secondary strike is protected or not. And that is why a limited reading is justified.
I'm in fact surprised that a union would offer that as a remedy for the harm, and would suggest that that is conducive to good faith collective bargaining in the mutual interests of employers. But I'll leave that point there. I'd like to have a look at section 22, which says every citizen has the right to choose their trade, occupation, and profession freely. And the next sentence, the practice of a trade, occupation, or profession may be regulated by law. Would that cover employers in the employees in a matter like this?
Yes, certainly.
So corporates.
Yes, it would. Yes.
And citizen is broadly interpreted.
Yes, it would.
Okay, thank you so much.
Thank you, Justice.
Thank you, Mr. Porter.
Thank you, Justice Kampepe.
Does that conclude your submission?
Yes, I think I've covered. I think the rest of it is in my heads of argument. And it's not necessary for me to repeat what is set out there.
Thank you. Mr. Mybeck?
Thank you. At the outset of our heads of argument, we deal with the issue of context. And we describe the context as secondary employers being innocent bystanders. A secondary employer is, of course, not itself a party to the labor dispute forming the subject of the strike at the primary employer. They cannot themselves accede to the strike demands. Nonetheless, their businesses suffer. What the LRA attempts to do then is to impose constraints on secondary strikes and their permissibility. And prime amongst those constraints and restrictions is found in section 66(2)(c), which is what this appeal is about. And what that section seeks to do in our respectful submission is to balance the rights of the innocent bystander versus the rights of employees to strike. In this appeal, AMCU advances two main grounds. Firstly, they argue that in assessing the permissibility of a secondary strike in terms of that section 66(2)(c), it's irrelevant how destructive the secondary strike is to the business of the secondary employer. They say harm is irrelevant. Secondly, what AMCU argues is that in assessing the impact of the secondary strike on the primary employer, one is entitled to adopt a cumulative construction. In other words, in this case, whilst they all but concede that a secondary strike by one of the minnow miners would have no effect, or would have had no effect on Sibanya, when you put them all together, when you put all of the respondents together and you see this on a broader industry basis, then there may have been an effect. Now, my learned friend has not dealt with this cumulative construction in argument to any degree. We've dealt with it in our heads of argument, and I'm going to confine my submissions then to really what has been the point of debate between my learned friend and the court, and that relates to the issue of harm. We, in paragraph 23 of our heads of argument, reproduce the text of section 66.2. And the court will be familiar with 66.2c. The plain language of that section reads, "The nature and extent of the secondary strike is reasonable." So I want to stop there. The words nature and extent, our learned friends give them a very literal and limited meaning. The nature of a strike, and I'll come to the jurisprudence, may encompass many things. The extent of a strike may also. But clearly that's the first inquiry. The nature and extent of the secondary strike. Where does that strike occur? Well, it occurs at the secondary employer's workplace. And patently, the consideration of the nature and the extent of a secondary strike involves a consideration of the effect of that strike on the secondary employer. Then proportionality is denoted by the words reasonable in relation to. So now we're comparing it to something else. And we're comparing it to the possible direct or indirect effect that the secondary strike may have on the business of the primary employer. Yes, that's an issue of leverage. Might the secondary strike cause the primary employer to concede? Now, we know, following the scheme of our heads of argument, that in 2008, in what we call Salgar 1, the Labour Court specifically considered two previous judgments, and in the quoted paragraph 26, departed from them and found expressly that an assessment of the nature and extent of the secondary strike clearly contemplates that its impact on the business of the secondary employer is a fundamental factor, and that an assessment of that impact is required. If I could take the court to the foot of page 11 of our heads of argument, because this is important, where the court then unpacks the meaning of nature and extent. Said, in short, whether or not a secondary strike is protected is determined by weighing up two factors: the reasonableness of the nature and extent of the secondary strike, and in brackets, this is an important part. This is an inquiry into the effect of the strike on the secondary employer, and will require consideration inter alia of the duration and form of the strike, the number of employees involved, their conduct, the magnitude of the strike's impact on the secondary employer, and the sector in which it occurs. Now, we know that the decision of Fanika J in Salgar 1 was upheld on appeal, where the Labour Appeal Court said in the final part of the quotation at paragraph 27 that under the head of proportionality, the court must weigh the effect of the secondary strike on the secondary employer and the effect of the nature and extent of the secondary strike on the business of the primary employer. Now, what is important with respect in our submission is the commentary of Thompson and Benjamin, because what they touch on, as you will see in paragraph 28 of our heads, is that in some jurisdictions, the so-called ally doctrine is followed when it comes to secondary strikes. In other jurisdictions, the so-called worker interest approach is followed. But they go on to say in the concluding paragraph of our quotation, this: the Act does not embrace either of these approaches, both of which have proved problematic at the level of judicial interpretation. Instead, it adopts an approach that requires the harm caused to the secondary employer to be proportional to its likely impact on the business of the primary employer. If it is left to the Labour Court, it is left to the Labour Court to define the parameters of protected secondary strikes within the meaning of section 66.2c. And really, it's that interpretation that has carried the day, certainly since the judgment of Fanika J in 2008. And then you will see that the Labour Court, we know at paragraph 31, adopted that approach, where it found that the mining houses in this case stood to suffer considerable losses, while it would have no effect, the secondary strike, at all on Sibanye, and therefore it was disproportionate. The Labour Appeal Court came to a similar conclusion in the sense that it endorsed the judgments in Salgar 1 and 2. And why there needs to be a proportionality assessment, where on the one hand you look at the impact on the secondary employer, on the other hand the impact on the primary employer, is because if one doesn't do that, then the secondary employer has no protection. It becomes a completely blunt instrument. If the only question is there possibly some implication for the primary strike, there's no protection to the secondary employer. And this case shows that. Here you have in some instances small minnow miners. They are pulled in a secondary strike. They are pulled into a dispute with a huge mining house. That mining house says that this secondary strike will have absolutely no impact. Yet there they are. They're going to suffer massive damages, ruinous damages. And what this is about, justices, is a balancing of rights. The rights, and there's a whole lot of different rights that favor the innocent bystander, balanced up against the right to strike. And what you do is you consider the impact on both hands, and then you weigh it proportionally, and you ask yourself, is the impact of one reasonable in relation to the impact of the other? And in our submission, this is not a case where the interpretation is really open to debate. In our submission, Salgar 1 and Salgar 2 are correct. And the stance that AMCU seeks to adopt is simply without merit. Those are our submissions. We also then go on to deal with the cumulative effect. From pages 15 and onwards of our heads of argument, we have nothing to add to that. I would just then deal with the issue of mootness. Of course, the Labour Appeal Court dealt with the very same question that the Constitutional Court is now confronted with. And what it found is that the law is settled both in relation to harm and in relation to the cumulative effect, and therefore found that there were no exceptional circumstances that would warrant the entertaining of an appeal where the dispute is moot. My learned friend, Mr. Boda, does now make reference to cost orders, but the court, of course, will be aware that section 16.2a Roman numeral 2 says, save under exceptional circumstances. The question when a decision would have no practical effect or result is to be determined without reference to any consideration of costs. So we say the fact that there are cost orders cannot be determinative. But those are, in a nutshell, our submissions.
Mr. Mybeck, I just need clarity on what exactly do we mean by proportionality here? Are we suggesting that the harm suffered by the secondary employer should be equal to the harm suffered by the primary employer? Or are we talking proportionality in the sense of justifiability? What are we talking about?
Justice Kampepe, as sorry, I beg your pardon, Justice Jafta, I'm terribly sorry. Perhaps I could take you to paragraph 26 of our heads of argument, where we quote from Salgar 1, where Justice Finico dealt with this. And what he said is, further, the use of the words reasonable in relation to, in section 66.2c, clearly import a proportionality assessment, not unlike the use of the term reasonable in section 36 of the Constitution, in relation to the proportionality assessment of the limitations on constitutional rights. So
I'm sorry, but that statement is not correct, because proportionality under Section 36 of the Constitution does not come under reasonableness. It comes under justifiability. That's why I'm confused. I want to know whether we are approaching the matter on the basis of what proportionality means is justifiable, or are we approaching the matter from the angle that you have to compare the harms between what is suffered by the secondary employer and what is suffered by the primary employer. If the secondary employer suffers more harm, greater harm than what the secondary strike impacts on the primary employer, then you can stop or interdict the secondary strike? Or are we saying the strike itself is justifiable? So I need clarity on that.
well, I think it's the first proposition that you put to me, Justice Jefter. It's a question of weighing up competing interests.
Yes.
And I think that reasonableness in this context probably does touch more on justifiability. So the question is, can one really justify, on the one hand, this much harm being caused to the secondary employer, where there's not a great likelihood or remote possibility of the strike having any impact on the primary employer? So it's a weighing up of those competing interests in that manner.
Okay, thank you.
Mr. Marburg? Oh, sorry. If there's someone else wanting to raise a question.
Sorry, my sister, just to put the follow one question on mootness. Would you accept, though, Mr. Marburg, that the section that you read back to us of the Superior Courts Act, does it apply to matters coming to the Constitutional Court? Isn't that here the test is whether it is in the interest of justice to grant leave? We have granted leave in numerous matters where the costs were the only issues arising. Do you accept that?
Well, I do accept, yes, Justice Jefter, that the jurisprudence of the Constitutional Court, ultimately the test is whether or not it's in the interest of justice. I do accept that, yes.
Thank you. Thank you, my sister.
Mr. Marburg, the Salga cases were decided on whether there was an effect, correct? Mr. Marburg?
Yes, I think, Justice Pillay, I agree with that.
Ultimately, and the proportionality was a statement made in passing based on the interpretation, but there was no evidence of any proportionality analysis and weighing of the kind that you suggest should be done in these cases.
I think that may be correct. Of course, Justice Pillay, you will be aware of the fact that, of course, the Labour Appeal Court first had to interpret the section. And I think that the high watermark of the judgment, certainly in our favour, is set out at paragraph 27 of our heads, where the Labour Appeal Court, and I read the quote, "In these proceedings quite properly, neither the appellant nor the union contest the proposition that section 66(2)(c) of the Act imports a proportionality test. What is required to be determined, as the court, our quo, correctly observed, is the reasonableness of the nature and extent of the secondary strike in brackets, which inevitably involves an inquiry into the effect of the strike on the secondary employer, close brackets, in relation to the effect on the business of the primary employer, in brackets, which inevitably involves an inquiry into the extent of the pressure placed on the primary employer. Under the head of proportionality, the court must weigh the effect of the secondary strike on the secondary employer and the effect and nature and extent of the secondary strike on the business of the primary employer. And yes, I would accept that ultimately the case then turned on the second inquiry, but as we have it, this is a clear statement of the law. And it's a statement, I suppose, importantly, that was endorsed by the Labour Appeal Court in this case.
Okay, if you go to the LAC judgment in Billiton, which overturned the outcome in my judgment in Billiton, the JP who wrote the judgment there did not use the word proportional in his analysis of the section at all. The word proportional occurs only once in recording what the employer's submission was. So proportionality analysis didn't even enter the equation. It was also decided on whether there was an effect. And in fact, in that case, on the facts, I refer to facts only by way of example as to when the facts are such that you can find that there's an effect. There was cross-holding of companies, and there was also some contractual relations between the secondary and the primary employer. But for that court, the effect was not high enough, was not sound enough on the facts. So when you say the starting point is the nature and effect of the strike, and that read with the word reasonableness invites a weighing up of harm to primary and secondary employer, or in this case, employers, that invites also then, you're saying, an interference in the power relations, power play. It could.
Yes, certainly. Now, I know that certainly when it comes to primary strikes, Justice Pillay, of course, that is taboo. The court doesn't become involved in the power play. The Constitutional Court has said that and similar things before. But that is in the context of a primary strike where, of course, the employer itself is in a position to resolve and settle the matter. Here we're dealing with secondary strikes, we're dealing with innocent bystanders. So the idea that the court may be clothed with the power to intervene in a strike in appropriate circumstances, in our submission, is simply a product of balancing up these competing rights and carving out some sort of protection for the innocent bystander.
Well, I must go back then to my starting point, and that is, if you're an innocent bystander, there's no effect. That's the end of the inquiry. And it's only if there's an effect that you look into the proportionality and you might look at this balancing. And when you're looking at the balancing, the protection that the secondary strike has, in the sense that the courts have been, and the legislation and the idea, the philosophy underpinning the LRA is that you don't interfere in the power play for as long as the rules of engagement have been observed. And so I'm looking at a proportionality analysis that is not informed by the power play. I would accept that that is conceivable. And as you would have heard me put to Mr. Boda, the entry for that is via the nature and extent into a constitutional justifiability analysis. What do you say to that proposition?
Well, I would think it's another way of looking at that. Our submissions rest really on the dictum, particularly of the LAC in Salgar 2, which I've read to you. But Justice Peter, it just strikes me that perhaps it's what you're suggesting is simply another way of getting to the point that we've been advancing ultimately, and that is what is inherent here is a balancing up of rights. Whether you do it through the interpretation that we advance or whether you do it through the Constitution, I think certainly we would endorse any interpretation or application that involves a balancing up of rights. And I suppose, if I may say, it might be that styling a secondary employer, and Mr. Boda makes this point, as an innocent bystander, that perhaps is overstating things. I mean, I suppose a bystander perhaps is a better term. I mean, there may very well be times a secondary strike against a minnow miner may potentially have some remote effect on the primary employer, but it's when you balance up how much harm is caused, then it's simply not justifiable. So I think completely innocent is probably overstated.
And just on the leverage factor, the fact that there was engagement at the Minerals Council level, but the absence of a culture or practice of bargaining collectively across companies, you're saying is not a strong enough effect, does not have a strong enough direct or indirect effect. Do I understand that? Thank you so much.
Mr. Myburgh, I'd like to take up just one aspect. It has become convention in the Labour Court and the Labour Appeal Court not to award costs, and that follows the judgment in this case was followed by that convention in Zungu, and Zungu endorsed what was said in KZN MEC of Finance versus Dawkin. I looked at the judgments of the Labour Court in the leave to appeal application and also the Labour Appeal Court's judgment. There's no reasoning on cost. It simply makes the cost orders. Do you still stand by the cost orders?
I'm afraid, Justice, that I don't have any instructions on that. I don't know if the court intends to break, but I would be happy to take an instruction. I'm obviously just not instructed to abandon those orders. I'll accept what you've said about the judgments and your summary of them. Perhaps I could take an instruction whilst Mr. Snyder is addressing you and then get back to that if I may.
Yes, thank you.
Sorry, Mr. Myburgh. Just one question I omitted to raise with you. There's no limit to how many secondary strikes you could have simultaneously, am I right? Nothing in the legislation.
In other words, how many separate employers you could target?
Yeah.
No, I don't know. There is no limitation, Justice Peter.
Thank you.
Thank you, Mr. Myburgh. Mr. Snyder. Mr. Snyder.
Apologies, Justice Kampepe. I didn't realize that I was still on mute. The focus of the hearing this morning has obviously started to zoom in very narrowly on an interpretation of the exact meaning and wording of section 66(2)(c), and perhaps to some lesser extent on section 66(3). If regard is had to the wording of section 66(2)(c), it must be interpreted in accordance with its context, in accordance with what it might seek to achieve, or the phrase sometimes used is the mischief it seeks to address, or perhaps mischief is a strong word. And looking at it in that manner, one has to question the distinction between primary strikes and secondary strikes. And as I understood my learned friend, Mr. Boda's argument, what he said is essentially you can't distinguish between the two. But the LRA very, very pertinently makes this distinction, and it makes this distinction in order to address particular issues. And one of the issues which it clearly seeks to address is a situation where a secondary employer that has no direct control over the strike is put in a position where it is simply a net loser. Remedies such as retrenchment, dismissals, the commencement of power play at the level of the secondary employer are, in my submission, simply creating conflict where none existed before. And with respect to the point that Justice Madlanga made earlier, that there could be an idyllic situation between a given employer and its employees, and then to suggest that that secondary employer must become involved in exercises such as retrenchment, which may or may not address the financial loss that it suffers as a result of the strike or any other loss that it may suffer, and that it may become involved in employing of alternative labor during the course of the lockout. All this, it occurs to me, is placing a secondary employer who does not have the direct approach of being able to accede to the demands in a position where it necessarily comes into conflict with its own employees, where it had no previous conflict with those employees. So with respect, those aspects of the LRA cannot be viewed as remedies for a secondary employer in dealing with the impact of a secondary strike. They are exacerbators of conflict, nothing more, nothing less. Now, the other issue that arises in that context is that there is no requirement to satisfy Section 66(2)(c) that a secondary employer be able to assert any influence on the primary employer. The strike is legitimate and protected in terms of the Act without that. So quite lawfully and without any compulsion to do so, and without remedy in respect of not having to do so, the secondary employer can well find itself where it has no influence over the primary employer. Whether or not the strike has an influence is one thing, but there must be, and again, just to illustrate by way of fact, Mr. Froneman, the CEO of Sibanya, went on record in this matter, and he says, I will not be influenced in this particular situation. I believe that a reasonable outcome with AMCU in the context of its employment relationship with this company is of a greater deal of significance. So as it turned out, no secondary employer could have influenced that particular dynamic. Now, bringing that to bear on the interpretation of 66(2)(c), to go to the wording, the nature and extent of the secondary strike. Now, strike in any copy of the Act will be highlighted because it is a definition in terms of Section 213 of the Act. And if regard is then had to Section 213, strike means the partial or complete concerted refusal to work, or the retardation or obstruction of work by persons who are or have been employed by the same employer or by different employers for the purpose of remedying a grievance or resolving a dispute in respect of any matter of mutual interest between employer and employee, and every reference to work in this definition includes overtime, whether it is voluntary or compulsory. So when one is looking at the definition of a strike and what a strike is, it's clear that what is contemplated is the retardation of work in relation to the employer concerned, not in relation to the primary employer in a secondary employer situation. And that is why the first part of section 66(2)(c) must be interpreted to relate to the secondary employer, because it says the nature and extent of the secondary strike. So that nature and that extent relate to the secondary employer is reasonable, and then that has its own meaning, its own historical, deeply jurisprudential meaning in our law, in our common law, as to how courts will treat the concept of reasonableness. And then in relation to, so it's now bringing in a secondary factor, a comparator, as it were, to the possible direct or indirect effect that the secondary strike may have on the business of the primary employer. There can be no serious contention with respect that this is not introducing a comparison between two different things. That this, as argued, can be taken to mean that the nature and extent of the secondary strike must be related to the primary strike. It just, with respect, does not make sense in terms of the language of this clause, the context, i.e. what is around it in terms of it being a secondary strike and different applications and different considerations taken into account on the one hand, and another primary strike on the other. It just can't be read conjunctively like that to apply in toto to the primary strike. Once, if justices, you are with me in regard to that issue, the question then remains as to, and this has been raised already, as to how one then does the balancing act. And that's exactly what it is. It is a balancing act. There are different rights at stake here. The right to strike, which no one questions the importance and the relevance of that right. Historically in South Africa, as the case may be, it is an important right. But there are other rights in this situation that have been mentioned in the context of Section 22 of the Constitution. There are other rights and there are other concerns involved here. And what a court, and I'm in respectful agreement with the first proposition that Justice Jackler made and the argument advanced by my learned colleague, Mr. Myburgh, that the court must do a balancing exercise to determine how much is the nature and extent of the strike impacting on the secondary employer. And it doesn't help to say with respect that the nature and extent doesn't mean harm. That's exactly what nature and extent means in this context, because it is the nature and extent of a strike that does harm. If a strike is a complete cessation of work in a 24-hour continuous operation company, and that cessation is throughout throughout that particular company, as opposed to a lunchtime picket where only those people, the company is minimally affected. There's no question that nature and extent implies harm. It implies degree. It implies the effect that it has on the primary, on the secondary employer. So that has to be compared to what is going on the other side, which is the primary strike and the possible direct or indirect effects that the secondary strike may have. So if the prospect is minimal, the proverbial minnow, that perhaps it would just meet this threshold, and a court decides, yes, it would just meet this threshold. But on the other hand, the minnow is being affected by the strike, and again, this was with respect to the point made by Justice Madlanga, is being exposed to a ruinous situation, which a complete strike is having on its business, and it can't, retrenchment simply won't fit the bill. Dismissals won't fit the bill. That is the point at which that balance would swing in favor of the secondary employer. And that's not to say that there can't be secondary strikes, because it's not the existence of the strike that is being challenged. This is not a situation where necessarily a company would get an interdict to prevent the strike in total. The employees may decide, let's make this strike harmful, let's make it impactful. Harmful, it may well be harmful on our employer, but not devastating, and let's make it impactful on the primary employer, and tread the path of reasonableness within all of this. So it is not a bar to a secondary strike. It's merely suggesting that because of the nature, the distinguishing factors between a primary strike and a secondary strike, that secondary employers should be afforded at least some level of protection, that there's an element of reasonableness in relation to what they suffer compared to the impact that the strike is having on the other side, on the primary employer side.
Mr. Snyder, your protection time has expired.
As the court, please, my lady. I was in any event.
Mr. Snyder, I'm sorry to interrupt you.
No, not at all.
Tell me if I'm wrong. You know, we lawyers, we like complicating language and provisions instead of simplifying them. Tell me if I'm wrong if I read section 66 to C to suggest, and I agree with you to the extent that you said, no, the secondary employer has no role. It doesn't have to put pressure on the primary employer. On the language of the section, it is the strike itself which must have the effect. Okay. Now, moving from the context that the purpose of the strike is to force the employer to go back to the bargaining table. Is it wrong to read section 66 to C to mean that for a secondary strike to be permitted, that strike, reasonably speaking, must have the effect of driving the primary employer back to the negotiating table? It must have, because it impacts on his business, he must be forced to go back to the negotiating table by the impact of the strike, the secondary strike itself, not the primary strike. The word reasonable is used to tell us that that test is objective. Objectively speaking, is the impact such that the primary employer would feel obliged to go back to the negotiating table? If it doesn't have that impact, then the secondary strike is not permitted because it doesn't have the effect that section 66 2 sub C says it should have. Is that a wrong interpretation?
Justice Jeffter, I would respectfully submit that it is, because the test for the impact of the secondary strike doesn't go to the word reasonable. It goes to in relation to the possible direct or indirect effect that the strike may have on the business of the primary employer. So my submission is that a court would test the impact of the secondary strike not
on what?
On whether in relation to the possible direct or indirect effect that the secondary strike may have. So in other words, the test is the test of reasonableness goes to the secondary strike. The test in respect of the impact, the test of reasonableness goes to the secondary employer. The test in respect of the impact of the strike is the possible direct or indirect effect that the secondary strike may have on the business of the primary employer. That is my submission. If one looks at the context and both the textual and the contextual meaning and the approach adopted in the Endumeni decision, is that is with respect the manner in which this section falls to be determined, because there is a reason for it, and it is submitted that the reason is not related solely to the interests of the primary employer. Otherwise, this section with respect wouldn't be here. The interest is related to both the secondary and primary employer, and for that reason, the word reasonableness reflects back on the secondary employer and the possible direct or indirect effect, because that's not reasonableness, that's a possibility. So in other words, if it's possible that this is going to have an effect, and it's a low threshold, as with respect correctly stated by Justice Pillay, then that meets that test. But one still needs to nevertheless look at reasonableness in the context of the secondary employer.
Now let's look at the text. The text says, the nature and extent of the secondary strike is reasonable. What is reasonable is the nature and extent of the secondary strike. Now, reasonable in what sense? It tells us, it goes on to say, in relation to the possible direct or indirect effect that strike, the secondary strike, has on the business of the primary employer. So the provision tells us, how do you determine reasonableness? You have to look at the impact that the secondary strike has on the business of the primary employer, isn't it?
With respect, Justice Jafta, my submission remains that the nature and extent of the secondary strike is reasonable in relation to. So one has to look at the nature and extent of the secondary strike, which, as I've already submitted, concerns the secondary strike within the secondary employer. And is that reasonable in relation to what happens with the primary strike? So in other words, is it reasonable to have a small company, which may have a minimal effect, crushed out of existence because it's having a minimal effect on a primary employer? That is as well as I can state my interpretation of this wording.
So the whole issue of striking would have to serve a different purpose other than the purpose of forcing parties back to the negotiation.
No, Justice Jafta, because the primary strike I think intimate is possibly the wrong word, but it's between two connected parties. They have a direct relationship. If you don't come to work, I can't make money out of my products. I want you to come back to work so that I can do that, and we're involved in this power play. That is the essence, as it were, of the distinction between a primary strike and a secondary strike. It's a different relationship. It has a different quality. The parties have influence on each other at a remove, not directly, as in the case of as in the case of a primary strike. And it's for that reason that this section exists. It is to address that separate situation. So the nature of striking doesn't change. And a reasonable strike within a secondary employer will still have an effect on the primary employer. It is just designed to offer a level of comfort, a level of protection on the side of the secondary employer, not to interfere with the right to strike as a whole, and certainly in no way to interfere with the right of a primary striker. Because with respect, Justice Jafta, if one takes the view that this must just simply be looked at in the context of the reasonableness of the strike in relation to the primary employer, then this is no protection at all to the secondary employer. And the question must then arise, why is this section here in the Act? And that it is difficult to find an answer to that question unless one says that there is a difference, that the existence of section 66.3 says that there is a difference. And as far as the court becoming involved in the power play, well, it's implicit in section 66.3 that there is going to be an element of court involvement. And in order to determine reasonableness, there is going to be an element of court involvement, which you wouldn't have in a primary strike. So perhaps what I'm trying to emphasize is that one, in interpreting this, and in terms of the principles set out in Indumeni, one has to look at it in context. It's in the context of a difference between a primary strike and a secondary strike. That's the context of this provision. And read in that context, it has the meaning that I've submitted, Justice.
And why then, in that context, would the protection afforded to the secondary employer be subjected to the link that the strike has on the business of the primary employer? Why not say the strike has this harmful effect on the business of the secondary employer, and the secondary employer must be given protection because he is an innocent bystander. He was not involved in the dispute that led to the strike. Why link it and say it must have a possible direct or indirect effect on the business of the primary employer?
Justice, I think that is a recognition of the importance of the right to strike, and of the solidarity principle, because you can't exclude it. Then there just wouldn't be secondary strikes. You'd say, well, if this is harmful to the secondary employer, well, then you can obtain an interdict, and that would abrogate the right to strike almost completely.
But I'm sorry, but you see, my problem is the secondary employer is an innocent bystander, innocent qualified in the sense of how Mr. Meyerbeck explained. Why really? Because the difficulty that led to the strike was between the primary employer and its workers. Now, the union wants to bring in a strike that is harmful against an innocent bystander. And we say, well, for the secondary employer to succeed to obtain an interdict, it must show not only that the strike has a crippling effect on its business, it must also show that the same strike that cripples its business has an impact on the business of the primary employer. That's where the element of unfairness crops up if one looks at the whole issue from the perspective of the secondary employer.
I'm in respectful agreement with that, Justice Jefter, that is the paradigm. And what the secondary employer has to show is that the strike is unreasonable in relation to the effect that its employees, it doesn't have to show other employees, which is part of the argument which my learned colleague, Mr. Marburg, dealt with. It doesn't have to show that on aggregate, there's no effect. It has to be able to say, my employees may well be able to have some effect on the primary strike, but they can't do so by doing what they're doing to my business. They may be able to do so by striking for half the day or a go slow or whatever the case may be. But what they are doing is unreasonable. On this side where I'm looking at it from, it's unreasonable because the benefit to collective bargaining on the other side, the right to strike on the other side is imbalanced, is disproportionate to what I'm suffering. So that's intrinsic in it, is to avoid lopsidedness in either direction, so that the important elements of the right to strike, the important capacity of employees to bring their employers back to the bargaining table or to achieve whatever other end the strike may seek to achieve, is not negated. But because it's a secondary strike, because of the distinction between a secondary employer and a primary employer that has been emphasized, the court is enjoined to be able to do a balancing act and apply, as your lordship with respect correctly said, an objective standard to balancing these competing rights.
Thank you.
Mr. Myburgh? Sorry, Mr. Snyder. Mr. Snyder?
I was hoping, Justice Pillay.
Didn't morph into Mr. Myburgh. You said there's a distinction between between strikes and secondary strikes in the Act. I read that difference to be about form and the way each is regulated. I also read through the Constitution that the strike, secondary or otherwise, primary or otherwise, would be balanced against all other rights under Section 36. What my question is, do you read in the Act permission to interfere in the power play in a secondary strike? I assume you accept that there's no right to interfere in the power play in a lawful primary strike.
I do accept that proposition, Justice Pillay. There is an explicit provision which allows the court to interfere in a power play in Section 66, and that is Section 66(3), that says, subject to 68(2) and 3, which are not relevant for our purposes, a secondary employer may apply to the Labour Court for an interdict to prohibit or limit a secondary strike that contravenes subsection 2. So that is an express right for the court to become involved in a power play, and
only if there is non-compliance.
Yes.
Only if it's so. I'm talking about where there is compliance, both in form and in compliance, in the sense that there is an effect. Of
no, my lady, if Section 2 is being complied with, and we're only really dealing with Section 2C, if there is compliance with Section 2C, well, then there would never, then the court wouldn't interfere.
Yeah, okay.
Then, it would only be in a case of non-compliance.
Right, I accept that. Now, nature and extent is wide enough to include not only the area of this around which we've been raising it or discussing this concept in the sense of introducing a proportionality or justifiability test. It also goes to looking at, for instance, I think if I use the Selga example, Selga case as an example, it would illustrate my point. That, for instance, if the strike in Selga involved the essential services, then 66.3 could say that the nature and extent violates other principles, the essential services provisions, and so the essential services workers should be excluded. So nature and extent could have that meaning. Nature and extent could have the meaning that you are saying, that the form of protest should be shorter, should be different from a 6-7 day long strike. So it is very wide and can include any number of permutations. So it's not only about introducing a proportionality analysis. Would you agree?
In that regard, Justice Pillay, my primary point about interpreting the words nature and extent of the secondary strike is that the nature and extent of the secondary strike relates to what happens vis-a-vis the secondary employer, in the sense that a 7-day strike would impact on the secondary employer for 7 days as opposed to for 2 days, as the case may be. A retardation of work would impact, etc. So my submission is that nature and extent in that context refers to the nature and extent between the secondary employer and its employees, not between the secondary employees and the primary employer.
I would accept, and I think it's consistent with the concession I understood came from Mr. Boda, that there is a weighing of the effect of the strike, provided there is an effect of the strike on the secondary employer, but not in a way that interferes with the power play. That's the difference. What do you think?
Again, I think one has to read it from the perspective of section 66.3. So you have to question what constitutes compliance. At what point is section 66.3 triggered in relation to section 2C? And it is my submission that it can't be triggered in isolation as to what is happening between secondary employees and primary employers, because how could one assess the nature and extent of that strike, of the secondary strike on the primary employer, if one was, again, not getting involved in the power play between the parties? There's an inherent issue here that regardless of the perspective that one attacks section 66.3 and how it is triggered, one needs to get involved in a debate about whether necessarily the court becomes involved in a power play. And the suggestion is then that the logical power play for it to become involved in is, and it's not actually even a power play if one considers it, because there is no power play between the secondary employer and its employees, unless it is created by the primary strike and the, with respect, intolerable solutions that were suggested by my learned friend, Mr. Boda. So there is no power play there. The court is not stepping into a power play. The court is stepping into a situation to see whether a secondary strike, which doesn't involve a power play between the secondary employer and the secondary employees, is reasonable in relation to what's going on the other side.
Well, my brother used the word leverage. The word influence has also come into play. So if there can't be power play if there is no leverage.
As a court,
and Mr. Boda's conceded a complete solidarity consideration only is not one that is contemplated by the section. Okay, and you would use section 66(3) when there is obviously all the procedural non-compliances, or when there is no effect. Also read section 66(3) to not exclude the application of the Constitution. It can't. So you would use section 66(3) to say it contravenes section 6, subsection 2, but it also contravenes provisions of the Constitution, even if there's a power play, because it's a balancing of the power play in relation to other rights that may be implicated, not necessarily only of the parties involved in the secondary and the primary strikes. Would you agree with that?
I would agree with that, Justice Pillay, and also identify with the remarks made by my learned colleague, Mr. Marburg, in relation to the same point. Yes, I can take that no further.
Oh, thank you very much.
Mr. Snyder, as you separately, your client separately also holds the costs order in your favor. I'd like to make the same inquiry I made with Mr. Maiber. Do you still do you still support the cost order against AMCU?
Justice Majid, I am reluctantly in the same position as my learned colleague, Mr. Marburg. I would have to take an instruction on that point. It's not something that I can address immediately.
Yes, I make that inquiry in the light of the decision of this court in Zungu, which endorsed the LAC's decision in MEC Finance versus Dawkins, which is a judgment that then JP Zondo gave in that court. So please think of.
Well, Judge, Justice, I'm not sure, in order to avoid delays, if we could address the court and our opponents in a one-liner in writing.
Subject to what the presiding sister says, I think that should be in order.
Yes, that should be in order, Mr. Snyder.
Thank you, Judge.
Does that conclude your submission, Mr. Snyder?
Does conclude my submissions. Thank you, Justice Computer.
Thank you. Mr. Boda?
I want to make three very short submissions for the court to consider finally. The first is this: the section doesn't read as follows. It doesn't say no person may take part in a secondary strike unless the nature and extent of the secondary strike is reasonable, full stop. If the section had said that, it would have admitted of an extremely broad inquiry. But the reasonableness inquiry is qualified by what appears after the word reasonable. It says in relation to the possible direct or indirect effect the secondary strike might have on the business of the primary employer. That is the only consideration. The second submission I want to make and ask the court to consider, it flows from what is set out in paragraph 69 of my heads of argument, where in Salga 1, this is what happened, where His Lordship Mr. Justice Van Niekerk said that the harm to the secondary employer is a relevant factor because it comes under the word extent. But then when applying the interdict, completely discounted that because of the finding that the inconvenience to third parties, the disruption of services and economic loss are not factors that rank highly when considering the legitimacy of industrial action. Rather, these are inevitable consequences which underpin the purpose of industrial action in any democratic society. And indeed, that's why workers who are in secondary strikes, which are protected, are also immunized from damages claims because they have this immunity against this. So it doesn't make sense to bring this into the equation, apart from the fact that it then brings and draws the court into the power play arena, which is not in accordance with the voluntarist nature of collective bargaining. And the final thought I would leave the court with is this: if the court is going to say that this is a factor to consider, it's going to substantially dilute secondary strikes as a weapon. And I've brought in the other weapons as that employers have, such as retrenchments and lockouts and replacement labor, not as solutions to the problem, but as illustrations of weapons that are available to the employer by the law in the power play and in the balance of that play. Now, the only weapon that workers have is the right to strike. And if the court is going to allow secondary employers to cry economic harm, the amount of secondary strikes that will find protection would be extremely little. And that's why one doesn't find many of them in the law reports. And where in the private sector, the labor court has been approached for interdicts, they've been successful precisely because the economic harm point has overweighed everything, when that is not the primary focus of the section. So those are the concluding submissions I'd like to make.
Thank you, Mr. Potter. Before we adjourn, Mr. Mybeck, have you been able to take instructions from your client?
Justice Kampepe, with your leave, might we also be permitted to put in a one-line letter to the court on that issue? As you can appreciate, we represent a number of different respondents, so it's quite difficult to get instructions on the turn.
Yes. Instead of a one-line letter, will it be adequate to refer to it as a one-line submission?
Yes, certainly. A short submission.
Yes. Thank you. Judgment is reserved and the court is adjourned.
Yes, the court, please.
Thank you, Justice.
Today's proceedings have concluded. The host will now terminate the meeting.